Добрый день, уважаемые коллеги. Приветствую вас на сегодняшней нашей сессии.
Good afternoon, dear colleagues. I would like to present you in our session the trends. I would like to introduce first the participant. It's Kazakhstan and Central Asia. They're also the head, and they will tell us about. And as you can see now, their presentation on mergers and acquisitions. And Boris, please start. You have 15 minutes. After that, if you have more questions, we will discuss. Thank you. My name is Boris Lobovik. Thank you for introduction. There is a presentation that we will look at. More than 15 years I'm working in M&A. It's one of the main practice in my field, and my colleague is also here, Sia, who will tell more. She works on a lot of deals. We have a big team in Kazakhstan and Central Asia regarding M&A. I can say that recently I read the book Daniel Kahneman about the memory, and there was this thing that the person has two types of perceptions. One is remembering self and experiencing self. So in the moment, it's experiencing when you are inside of the deal, because the sleepless nights, this constant stress, the pressure from the client, pressure of circumstances, deadlines. So the time goes quite exhausting, and in a year or 6 years, you think about those deals with a very warm feelings, and it's one of those bright memories which I have in my professional field. It's what I can remember and what I am proud of, and therefore it seems like, well, okay, seller, buyer, object, somehow it should be enough, but nevertheless I had done a lot of deals, and each of this deal changes your expectations, and I understand that it will be something new, something interesting, because the deal is not about papers, it's about the people, which from the side of the seller, side of the buyer, have different priorities and different objectives, and it's a different industries. It can be FMCG, oil and gas, IT. So all of it is quite different every time, and the deal fills you out as a lawyer with the different types of knowledge, not only as part of the corporate law, but in terms of the other types of law, and to understand the industry of the business, it will becomes more agile and more business process oriented, and before we go to the description of an M&A from the legal point of view, a few words on how it looks like. First, the classifications and what type of sales of business is possible. It can be the bilateral sales, so when there is a seller and a buyer, they sit down and then they discuss it, and then on how to structure the deal, how to make it. And there's auction sales, what is called structured sales process, and when there is a seller and they want to accelerate the process in a way to involve more type of potential buyers. So briefly, structured sale.
Вы видите на экране там какие-то основные опасения покупателей.
Here on the screen, you can see some worries of the buyers during the auction. Probably for them, it's not so advantageable. We do not have enough time. That's why I will not go into details, but I will be happy to respond to the question. And it's a very broad topic. We can discuss this topic for several days. And the second layer of classification, this is as deal or share deal. So what we sell, we sell the corporate rights of the company, holding or operational one that owns a business, the focus of the business, or probably it procures a physical asset, building, for example, the intellectual property right. And of course, a share deal envisages rapid processes and streamlined processes. It's more simple because you buy shares and the business is transitioned with it. And in case of assets, there can be some problems that have to be taken into consideration. For example, taxation, the transition of employees, or probably the transition of the revenue that was accumulated over last periods, a goodwill transition that needs to be formulated. And here you can see a pie chart that shows for itself its statistics for the previous year. So on the bills in full world, and actually they happen in a share deal where based on an agreement on shares from the seller to the buyer, the ownership rights are transitioned, and that is why this pie, what you can see here, we can see a small share of present deals, and we will discuss it further. And probably, in my personal opinion, SN deals is when the procurement of shares is a deal breaker because of some reputational or taxation risks that are connected with the company that can be transitioned to the buyer of the shares. As I have already mentioned, of course, this process is quite creative, and all the time it can be new and different, but at the same time, we have general chapters in this book that we can see on the screen. And very often there can be a preliminary document, LOI, for example, and then the buyer makes a legal due diligence together with taxes and so on, environmental, for example, different combinations of due diligence. After they conduct due diligence, and the main preliminary documents acceptance and approval of third parties, the signing, and some post-closing tidying ups, and you have 5 minutes more. Okay, so what I can say, so the main, what we are working with, this is the SPA, because it makes main agreements on the deal. Probably I will omit the preliminary agreement. As for the preliminary agreement, first of all, is needed. If, for example, the agreement is complicated, everyone have to remember what they have agreed upon. Probably it doesn't have the legal force or binding, but the most important thing from the general understanding point of view between these parties, that in 1 year when you make when you sign the SPA, you could remember what you have agreed upon. And as for legal due diligence, it's all clear, I think. But the main issue here is that the result of the due diligence impacts not only on the price of the agreement, but also it should be reflected in the documents. If there is a risk, probably it can be reflected in warranties or indemnities or in the structure. It's very important to develop the whole process correctly, not just at the stage of due diligence, but to continue the work, the activity, in order to make the work quality. And SPA is the main document. It's in any shared deal, but depending on the structure, it can be a full or partial selling, and there can be different documents that they can be documents that guarantee the payment, or sometimes it's the share agreement or shareholders agreement. for a joint ventures, but the seller, for example, remains in the business, but they need to make some rules of the business, how to operate further. On the other hand, they need to understand how to manage, for example, shares of different periods and so on. So thus, we make the shareholders agreement. As for SPAs, the most important document, main part is to agree on the price, the order of payments, the preliminary conditions, and write-ups. And as for the liabilities, which is first of all, it's a limitation of liabilities, the warranties of parties, and some indemnities. Well, the procedure of agreement, for example, if it's not in Kazakhstan or Cyprus, Holland, Singapore, Luxembourg, because every country has own peculiarities, you have to be aware about them, how to transition the rights to the shares. Yes. I will give the floor to Ms. Gulfia Kurmanova. She will say words about agreements and approval of agreements, in particular at Kazakhstani level. Hello, dear colleagues. Like Borisa has mentioned, we support different deals in Kazakhstan, and the most important stages is the closure or commencement of the agreement. Despite after signing, some people may relax, for example, the counselors, the parties of the agreement, but nevertheless, at this stage, it's very important to work with lawyers, because when you close the agreement, when you make all the legal conditions of the agreement so that the property ownership right could be transitioned to the buyer. In particular, here we need to receive different approvals. For example, if, for example, transnational companies are parties of the agreement, it can be multi-layer process of taking decisions to agree upon to see whether all the approvals were received from the parties. And another important moment is to receive all regulatory approvals. In Kazakhstan in particular, it's the agreement on the economic situation, and all the agreements should go by it. First of all, I think that many of the parties exceed the threshold. If, for example, transnational companies participate in the agreement, so regulatory approvals can be received in other countries. In our practice, in particular, we had different deals when such approvals were received from 3-4 countries in the countries where the seller operated. And it's a long-term process to receive all the agreements, and that is why the process of completing transaction can, for example, take from 1 to 3 years in negative scenario. And in our practice, of course, it's standardized as 6 months when we can complete a transaction. I think that's it about completing transaction, and the role of the lawyer is very important here to monitor the fulfillment of all preliminary conditions and receiving different approvals based on the legislation, so that all the approvals, corporate approvals, could be made based on the corporate documents in order to exclude different probable risks of disputing them in the future. We have a question from the participants of the conference. The Institute of Indemnity, does it work in Kazakhstan? Dear colleagues, most of the deals, even though they are made in Kazakhstan with Kazakhstani assets, they are structuralized based on the common law, especially if it's a holding company. And moreover, this allows to subject the foreign element to the local legislation. That is why the foreign element, whether it's the buyer or holding company, you can find them easily. If the English law, the indemnity can be applied, but the issue is how to solve the disputes. For example, arbitration, it can be in London, and how to fulfill different words in the practice. It can be based on the convention. If we take the Kazakhstani law, of course, we understand that indemnity should be interpreted to the language of civil law. What's indemnity? It's when we have a specific risk and the parties understand that there can be a tax, for example, monitoring or some problems with the license. It means that the barrier will cover all the damages, and we need to quantify the amount of the damage, and the parties have to understand that the damage of the buyer will be equal to a specific amount, and then it can be qualified as a real damage based on the Kazakhstan legislation. Hope I answered this question. Thank you very much, Boris. And also there is a question about the liability of the lawyers. So on the due diligence conclusions, we know the case with CMS when a bilegal company they shared the signed pages of the agreement, and because of the mistake of a lawyer, unfortunately, they signed not the last version, but the previous version of the document. And CMS also bear some losses. They paid millions of USD of penalty. In Kazakhstan, do we have a regulatory basis on the responsibilities or liabilities of the lawyers in preparing such documents? For example, in personal conclusions and so on. First of all, it's a question of agreements. We have the agreements between clients and legal companies, for example. It prescribes the order of making different agreements, and international companies of big lawyer firms have the insurance that can cover different risks for hundreds of millions of dollars. And international big company, for example, and our work is and our experience is based on avoiding such mistakes. But if we have them, we have the methods how to compensate this damage. We and our competitors, I mean. And yes, I have heard, sometimes I hear about such problems, but one of the perks, if we take a big lawyers company or legal company with good record in other countries, if they have problems, they are comfortable to solve the problem. But if it's not solved, the company can pay the compensation with the use of insurance and so on. Excellent, thank you very much. And now I would like to introduce the next speaker, Roman Hadikin, the partner of Brian Cape, Leighton Pisner, LP, International Arbitration and Cross-Border. Roman, please turn on your presentation on the screen, and you have 15 minutes. Good morning, dear colleagues. Well, just a second. I will try to show the presentation on the screen. Okay, can you see the presentation? Yes, I can see the presentation. Good morning, dear colleagues. I will speak about international arbitration and transboundary bankruptcies, but because this topic is huge, we cannot cover it fully. I try to focus on several moments so that to speak about them rather than to speak about everything just in brief. And accordingly, international arbitration. So why do people choose international arbitration? And we have listened to about international deals. For example, it was interesting. And there is a question, parties agreed to buy the shares in Kazakhstan or somewhere else. And there is a question, if there is a dispute, where they will solve it. And the first question that is important, what's important for us? When you choose a court or arbitration, what's important for you? And first of all, is applicable law. For example, if it's English law, does it or will this dispute be considered in the courts of Kazakhstan or Russia? And there is a very important moment, and our colleague Boris has noted that the deals are structured based on English law. And of course, this law has a reputation as a business focused law, and many people choose it for own deals. But I have been dealing with arbitration for many years. I've seen many disputes on Kazakhstani law, German and French, and even Afghani law. I had a case on Afghani law, and it was very hard to find the experts in the field of Afghanistani law. And over these years, in many cases, laws and law systems comes to the same results, but with different names. So probably you're aware that in English law, it doesn't have the clause on the fairness behavior. But in American law, it's an implied term and it's absent in English one. Why so? It has own rules. For example, when we make negotiations, we do not have them. And if you try to sue someone for unfair behavior based on the continental law, you will refer to fairness, or they can be different mechanisms, but the result is the same. First, what you are looking at is how you choose an arbitration and applicable law. Next is neutral and independent court. And probably it's the most important factor. When people that are very close to the governing elite, for example, people will doubt whether to approach to this court or not. And England is very popular here because 30% of all the disputes are not connected with England itself. And let's take serious countries that go to England and consider their disputes are there, and English courts are recognized as competent and independent. And many indeed go to England to resolve the disputes. Another is the speed of consideration, because arbitration is very good for difficult deals and agreements. But arbitration, for example, is slowly. It's quite slowly than the state courts.
Я помню прекрасно
I worked in a shell company in Sakhalin, and I remember exactly this discussion with business when arbitrage would take like 12 to 18 months, and they would say, listen, we cannot wait for that much. With our contractor, we have work, and while there is a discussion, we cannot, everyone is busy. For us, it's the time matters. So for this type of disputes, there is no need whether it's fair or not fair. For us, it's important to have it quick. Even if we lose, it's just losses and we move forward. For more serious situations, especially when it can create some form of precedent, we then shall, for example, had a policy to have an arbitrage in Paris on certain deals. It's a London international court. So also the decision and fairness, as Boris stated, in case of the tax inspection. Similarly, arbitrage, we need to understand they request more losses, especially the lost opportunities, lost revenues. It's very difficult to claim those in certain countries, and because as we know, the courts are motivated by the sides that could not prove, give evidence for their losses, and if you could not prove it, then on the same standard, since it did not happen, the so-called opportunity loss, right? So what could have happened if there was no violation? So I had an interesting dispute. Endemic had the tax inspection, and they listed everything as losses. And 1 minute, there's some technical. indemnity, there was the tax inspection, and client was thought that, for example, taxation counted 5 million USD. And for 5 million USD, they thought that the 5 million USD should be claimed by tribunal. However, the approach is somewhat different when you calculate indemnity. You should see on what formula had you bought the company. So in this case, the company was bought with EBITDA. Their profit was calculated multiplied by 4. So what you had done, you had to this 5 million subtracted from the profit, recalculate the EBITDA and multiply by 4. So then this sum was more than 5 million. One more time is the confidentiality. How important is confidentiality? Because as we know, there is this thinking that arbitrage selects confidentiality because confidentiality is needed only to do some dirty thing, to hide some dirty manipulations. However, confidentiality for public companies is also important.
Представители там Ernst Young, большой четверки, да?
Representatives from REI, the Big Four, and indeed,
Артур Андерсон,
was
что
Big
кто знает, что с
Five,
ней
there was
случилось?
Anderson,
Большая там аудиторская компания, и потом против них начали гражданское дело, уголовное.
successful big auditing company, and then code, and then there's
Что делают клиенты? Естественно, все клиенты проголосовали ногами, все от
so
них
what does the
ушли.
client do? So all the clients voted, then one left, and then a couple years ago, the highest score
Дело прекратить, но от компании уже нет. Так вот, вопрос, что если бы это было в конфиденциальном режиме, наверное, эта компания...
So company can then, for example, I had a confidentiality where I represented Bank of New York, and in the court, there was certain comment that the lawyers stated that they have to have the case against Bank of New York, and the shares of New York went down by 10-15%. So confidentiality is important, and lies the possibility of execute the decision. I will talk about it later. Now, if we talk about, and we thought about these factors, and now we think and analyze arbitrage, and of course, arbitrage can allow you to consider certain factors. Not everyone, first of all, whether you can execute the decision, because it's important to resolve the dispute so that you can execute a decision. And there is a convention of New York by 1958, and it talks about it was ratified in more than 140 countries, and the execution of the arbitrage is much easier than the execution of the courts. I don't even know how many treaties Kazakhstan has regarding the execution of the decision. For example, Russia has not many. It's only they don't have this treaty with England. They don't have with the USA. They don't have with Germany. So it's much easier to execute the arbitrage decisions. Second is the professionalism of arbitrage, because if you go to state court, you are being assigned by the court with the judge that is free at the moment. He will not have a specific specialization, especially if you're talking about English law or the some, French court, and he might not know this, and then he needs to read and get the details of it. But when you go to arbitrage, you can appoint a certain person which would understand, for example, the insurance industry or taxation industry, or will be expert in English law, for example. Then it also resolved the issue of the corruption in the court. Also, arbitrage has a more flexible approach in terms of the evidence and the process governance. There are no some strict requirements that you cannot attach emails, that it's not the evidence, that you have to have a power of attorney. So an arbitrage will accept it, and of course it's confidentiality because there are certain exceptions, but the majority there is some difficulties with confidentialities, and most importantly, arbitrage is a non-state court, and the advantage of the state court is that it's forced to execute. Arbitration cannot do that. However, in many countries, there is a mechanism when you can include some provision measures for that to happen. So, so you don't have to go to court to have these measures exercised. Last is this. Here I would like to say a few words. It's important when you select the arbitrage. The plus is that you have and that there is a chance to, for example, you face a contra-agent in Mongolia, and then you said, for example, oh, it's against the public order. So your contra-agent has assets, operations abroad, and then I had a case, for example, when in Russia, we could not exercise this decision, and then we went to China and arrested the funds. So all of the currency corresponding accounts of the USA, you just go there and you execute the decision there. So it's very interesting that when the arbitrage had made a case against Aeroflot and the decision was changed in Russia, when the court usher came, and then there was Berezovsky at that moment, and the highest court had said that decision is not executed. And Canadian company, they went to Canadian court, and then they got execution there. And the lawyer that was representing, they said, they called to Aeroflot and said, a good way, just give them the money back, because otherwise your airplane will leave Montreal. And as the lawyer said, the general director said, we'll see. And then next day they come to Montreal, I bought airplane, and then
пылесосами, значит, загрузили пассажиров. Пока пристав, в общем, бегал по этому аэропорту, самолет уже отцепился и едет на взлетно-посадочную полосу. Значит, ну, пристав забегает к диспетчеру, говорит, я там пристав, остановите самолет. Соответственно, пилот запрашивает разрешение на взлет, ему разрешение не дают, говорят, к вам тут пристав, съезжайте на рулежку. Ну, в общем, все заканчивается тем, что пристав приезжает в этот самолет. Приезжает в этот самолет, и, как говорит пристав, пилот, говорит, вел себя очень...
The pilot was behaving.
Я почему-то слышу перевод. Так, пилот, соответственно, вел себя нагло, он подвел его к табличке такой металлической, прикрученной 4 шурупами, на которой было написано, что самолет в лизинге и собственностью компании Аэрофлота не является. И он показал, соответственно,
It was written that the airplane is in leasing, and then see, it's not our airplane, and then the court usher said that the pilot was behaving themselves not in a good way, and if it was a Russian court service, they would say that you're not behaving yourself well, but this was a Canadian court service, so they said, listen, I'm not reviewing it. I'm reviewing it as a insult to entire court system. It's not your airplane. Is it, how do you plan to feed them? Then get all of the fuel and then plan to fly. So without next time it was all paid for the very last penny. So it shows that the company with international operation, even if they could not execute with this advantage of the arbitrage, that you can use it in the different countries where you can find assets, or in that case, you can execute it. Next is whether you can execute the arbitrage decision if it was canceled. I'll give you 2 or 3 examples which had such significant cases when arbitrage made a decision and then state law canceled it. For example, Yukos versus Rosneft, when the decision was against Rosneft. It's one of the very influential company in Russia, and state court planned this. Nevertheless, the Yukos made this into force because they showed that all of their reasoning was caused by corruption, and at the same time, there were 2 more decisions, the Yukos Capital versus Rosneft and Maximov versus NMLK. This was a more complicated situation because initially it was executed in France and then it was canceled, so they could not be executed, and the judges are being moved by the fact that based on the court should decide at the local point. So based on that, I would want to end my presentation. If there are some questions I would like to answer, in my opinion, arbitrage is more applicable because arbitrage could be in Kazakhstan.
Да, то есть он может быть там в Лондоне, в Стокгольме. В советское время, например, Стокгольм активно использовали как нейтральный форум в сделках с американцами. Вот, там Лондон известен как арбитраж для финансовых сделок. Вот, то есть, ну, в принципе, вы, наверное, должны исходить из того, что вы хотите добиться при разрешении споров, на что вам важнее, скорость или качество рассмотрения спора, знание иностранного права и так далее. Вот,
Роман, спасибо большое. Да, извиняюсь. У нас есть 2 вопроса. Во-первых, о применении медиации в трансграничных спорах. Встречаетесь ли вы с такой практикой? Есть ли такая практика?
Да, и практика такая есть. Надо сказать, что медиация, посредничество, да, то есть вот по моему опыту, когда ну, как бы там клиенты из СНГ, там им кто-то говорит, а давайте медиацию, я говорю, что это такое? Это вот специальный человек придет и вас помирит. Они все мне говорят примерно одно и то же. Ну что за человек? Если я не могу договориться, почему он договорится? Я там бизнес построил в 90-е, я пол Сибири в ушанке прошагал. Они мне сейчас будут рассказывать, как переговоры вести. Но на самом деле медиация достигает успеха в 80% случаев, потому что бизнесмены часто смотрят зашоренно. Они договариваются только о цене. А хороший медиатор, он умеет расширить вот эти границы сознания и какие-то найти компромиссы, которые не связаны напрямую с деньгами. Поэтому у меня был, например, большой спор, где французский банк пытался купить русский Стандартбанк. Они все там очень были обидчивые, судились в 9 странах, и потом их заставил судья, английский был судья Колман, заставил их пойти в медиацию, помирил. То есть это на самом деле очень успешная практика. Другой вопрос, нужно ли включать в договор это?
Another thing is whether we need to provide it in a contract, and I think that there is no need because if you include it in a contract, when you go to arbitrage, you need this is then we can start arbitrage, and if you need it before that, you can start before you execute the main item, and this cannot.
Роман, спасибо большое. Следующий вопрос у нас касается конфиденциальности. То есть вы говорили о том, что арбитраж более выгоден тем, той стороной, что он является конфиденциальным. Соблюдается ли режим конфиденциальности рассмотрения государственных судов в Англии? То есть можно ли там применить такой режим?
Нет, ну теоретически можно, но практически нет. То есть даже не так. Скажем, рассмотрение дел или ходатайств, связанных с арбитражем, оно конфиденциальное.
The review of the cases related to arbitrage is confidential. You cannot just come to the hearings As per the general rule, all of the
В государственных судах, например, СНГ, потому что, я так понимаю, в государственных судах СНГ, хотя все там материалы, ну, все даты, все там какие-то основные вехи на сайте можно найти, но сами документы, материалы дела почитать нельзя. Так вот, в судах Англии
but you
любой человек,
cannot read
журналист,
the
может
actual materials. And any journalist can come and say, I want to read the case of Berezovsky against Abramovich, and then they will be given it, and then he can read it. So I think it's only about the transporter cases. If you look about the arbitrage, for example, certain measures to protect, or for example, to cancel the arbitrage decisions will be confidential. Or, for example, some categories are talking about protection of underage. It can be confidential, but in general, it's very open.
So we have a question,
Roman, we have
and
one
in
more
another
question. In a different
conference, we were discussing
conference, we talked
the
about the
differentiation of
the
applicable
division
law.
of the applied law. Can you again mention about that? It's called dépostage, and it's a French term, and it's translated. It can also be translated as a right. So sometimes when we said that the contract is under the English law, it does not mean that everything will be under English law, because sometimes the signature of the signatories, the authority of the signatories, and the dispute can be then managed by the law of the corporation of that. And then procedure, for example, will be regulated by the arbitrage. Then it will be some contractual regulations, and certain things will not be under that. Nevertheless, even you can segregate the contract, and you can say that some of the sparse contracts can be under that law.
Товара происходит, например, в Японии, а право английское, и могут просто сложности возникнуть технические, найти там английского юриста, который приемка там соответственно.
Technically, it's very hard to say. For example, if we take the Japan or Chinese goods, it can be so you can use the local law. There can be, for example, different Rome conventions or Rome regulation 1 and so on. But what's not recommended, and you can, for example, split up different parts of the agreement, but a specific part of an agreement, you cannot do that. For example, you cannot subject the legal liabilities of the seller to one law and the buyer to another, because there should be the corresponding correlations between these two parties. And in this case, there cannot be any conjunctions, for example. And when you subject to a specific part to the foreign law, please pay attention that the rights and liabilities could be.
Introduce you to Leon Ismail, Squire, JD and LLM in Philippines and New York, Dean of Law Faculty of Cebu University, Philippines. With the theme of his introduction is cross-border transactions, trends, challenges, and opportunities. Please, could you please start?
All right, good afternoon, everyone. Happy to be here. For this afternoon, I'm tasked to discuss trends, challenges, and opportunities. I understand I only have 15 minutes. I hope I could finish everything. The globalization of economics and commerce in the past few decades has spurred increases in cross-border investment and trade. The changes in investment and trade patterns have led to more complex commercial relationships between investors and the local governments that attract peculiar and intricate legal issues extending beyond the application of underlying conflict of law principles and the issues of cross-border litigation and arbitration. These relationships and legal issues necessitate a deeper understanding of laws, rules, and regulations governing international business transactions and a wide spectrum of transaction types. Handling and negotiating cross-border transactions, for example, require not only familiarity with jurisprudential issues, international laws and treaties and principles on international contracts, but also information technology, intellectual property rights and technology transfer, trade financing, insurance, corporation law and securities, and even competition law and other international business regulations. And of course, also cultural and business practices of the world superpowers. Now let's look at the recent trends in cross-border transactions. First one is the Inco Terms, which took effect on January 1, 2020. So Inco Terms are a series of predefined commercial terms published by the International Chamber of Commerce relating to international commercial law, and they serve as a global standards for uniform interpretation of common contract clauses in international trade. Inco Terms allow parties to designate a point at which the cost and risk of transports are precisely divided between the seller and the buyer. However, they do not determine ownership and transfer of title. Since Inco Terms are not law but are contractual terms, they do not apply to a given transaction unless the parties specifically incorporate them by referring to the last version of the Inco Terms. The first one, the first amendment is that of providing an option of bill of lading with onboard notation. Now, in the Inco Terms 2020 version, this option is specified for maritime transport so that buyer may instruct the carrier, which has been contracted in order to issue a bill of lading on behalf of the seller with the annotation of on board, which specifies that the goods have been loaded aboard the ship. This is the most common shipment document, which is used in the letter of credit transactions in order to substantiate the delivery of the goods and thereby payment of the credit to the seller. And then you have DAT, which is basically the renaming of the old Incoterm DAT. In the Incoterms 2020, a new Incoterm DPU is created, replacing the DAT, or delivered at terminal. This change of acronyms is simple renaming given that the obligations and functions of both terms are exactly the same. DPU is the only Incoterm in which the goods are delivered, unloaded at the place of destination. The change of name is substantiated as the goods cannot only be unloaded at a transport terminal infrastructure, but likewise at any other point in the destination country, which has facilities for the unloading of the goods from the means of transport. Another amendment is with respect to the obligation.
Excuse me, could you please slow down?
Customs clearance is more precisely explained and identifies which party, seller, or buyer is responsible for carrying out customs formalities and clearance, assuming the costs and risks thereof. And the release of goods in transit is included for the first time. Now, for the latter, the rule which is used is that the liability is assigned to whoever assumes the risk of transport to the place of delivery. And this change may be significant in international sales, wherein the goods must pass through customs of complex countries prior to arriving at the customs of the import country. Then you have transport security requirements, which are now addressed more precisely in the Incoterms 2020. And these are addressed precisely under two circumstances: transport from the country of origin to that of the destination, and customs clearance facilities and procedures. Now, during the transport of the goods, the security liability is assumed by the party who executes the carriage of goods contract. That is the seller in Incoterms CPT, CFR, CIP, CIF, DAP, DPU, and DDP, or the buyer in the case of Incoterms EXW, FCA, FAS, and FOB. As customs clearances are concerned, the safety liability lies with the party which must undertake the safety. Next trend in cross-border transactions is environmental conscious business practices being imbibed by many companies. As the environmental risks and effects of climate change are becoming better understood, sustainability is high on the agenda of many major global corporations. Recent international legislations and proposals have put environmental issues at the forefront of international business development. On a practical level, if you're considering expanding your business overseas, it's important to be aware of the country's specific environmental regulations and issues associated with their industry. Some key considerations include how your production methods might impact the local environment through waste and pollution. Beyond a legal or ethical incentive to be more eco-friendly, establishing environmentally conscious business practices can attract new, forward-thinking consumers to your company. With the number of brands leading a shift towards the circular economy, there is an opportunity and demand for changing the production methods and consumer behavior.
Sorry. Could you please speak slowly, please?
Okay, sure. And consumer behavior to establish a more sustainable future for the environment and society as a whole. Now, in one of the current transactions that I'm handling, particularly involving corporate structuring and debt restructuring, there had been some clauses relating to environment were already incorporated, such as those pertaining to environmental compliance, environmental claims, environmental and social incidents, environmental action plan, environmental and social KPIs. Now, probably these clauses are found in most loan documents where the IFC of the World Bank or the Asian Development Bank are involved. This is actually based on my experience. Now, the third trend in cross-border transaction is that of regional economic cooperation and integration. Now, one of the greatest challenges that stand in the way of creating a world free from financial borders where cross-border shopping can flourish is protectionism and trade wars amongst government. This type of backward mentality is harmful to commerce, e-commerce, and international expansion. Ultimately, it will impact innovation and the scaling of this innovation. Regional economic cooperation and integration is an important means for creating new trade, investment, and employment opportunities, enhancing economic security, and addressing addressing broader socio-economic and environmental issues. As Asia continues to experience major demographic shifts, a growing middle class, and expanding domestic markets, more countries are recognizing that deeper integration can accelerate their collective economic growth and development. Let's look at the recent economic cooperation or integration agreements that have been entered into by various countries. The most recent one, which was just signed on November 15, 2020, is that of the Regional Comprehensive Economic Partnership. 10 ASEAN nations, plus 5 other Asia-Pacific countries, and these are Vietnam, Thailand, Philippines, Laos, Cambodia, Myanmar, Malaysia, Singapore, Indonesia, and Brunei, and the 5 other Asia-Pacific countries like Australia, Japan, New Zealand, and South Korea have signed these agreements. Now, the pact is expected to drive economic growth in a region hard hit by the coronavirus pandemic. The pact lowers tariffs, opens up the service sector, and sets common trade rules within the bloc. The agreement covers trade, services, investment, e-commerce, telecommunications, and copyright. However, the agreement does not include environmental protection and labor rights or commit countries to open services and other vulnerable areas of their economies. It does, however, set rules for trade that will facilitate investment and other business within the region. And then you have the USMCA, or the United States, Mexico, Canada Agreement, which replaced NAFTA, or the North Atlantic Free Trade Agreement, which took effect on July 1, 2020. As many of you probably know, after the former US President Donald Trump took office in January of 2017, he sought to replace NAFTA with a new agreement, begin negotiations with Canada and Mexico. In September of 2018, the US, Mexico, and Canada reached an agreement to replace NAFTA with the USMCA, and all the 3 countries had ratified it in March of 2020. NAFTA remained in force until USMCA was implemented. In April of 2020, Canada and Mexico notified the US that they were ready to implement the agreement, and the USMCA took effect on July 1, 2020, thereby effectively replacing NAFTA. It is believed that the USMCA creates a more level playing field for American workers, including improved rules of origin for automobiles, trucks, and other products, as well as disciplines on currency manipulation. Now, those are the 3, I think, more relevant trends in cross-border transactions. And we now move on to the challenges. Now, first one is legal issues in e-commerce. One might think that e-commerce is more sustainable because buyers aren't traveling to stores, but that's not necessarily true. In fact, e-commerce is only more sustainable when parcels are received on time or delivered from local warehouses as opposed to being flown across the country and aren't returned. That's a lot of criteria to get it right. Now, the e-commerce ecosystem has become one of the most crowded startup spaces over the past few years. The e-commerce industry, just like every other niche within the tech industry, has had to adapt to an increasingly demanding legal and regulatory environment that has often led to lawsuits, product recalls, and closures in some parts of the world. For entrepreneurs running e-commerce startups, legal infractions come in many forms, with each infraction presenting a different challenge for the business. As such, it is vital for every e-commerce outfit to stay ahead of the game when it comes to individual legal responsibilities. And then you have first issue relevant to e-commerce is liability and contractual information. Now, defining terms and conditions agreement for your e-commerce business is also paramount. Most people are accustomed to agreeing to a business terms and conditions without fully reading or understanding them. Nonetheless, they're vitally important for a business owner in terms of resolving legal matters. In a basic sense, the terms and conditions set the ground rules for all of your online transactions. At a minimum, these rules should establish the limits of liability should the product fall. Generally, a business terms and conditions are there to protect the company and establish a procedure in the event of a legal dispute. Amazon, for example, which is easily the most recognizable face of the e-commerce industry, has faced legal scrutiny for its practices. In 2018, the US Court of Appeals for the Third Circuit ruled that Amazon was liable for a dog collar that it sold from a third-party vendor that caused permanent vision loss to a Pennsylvania woman. For the average e-commerce startup, the ruling illustrates the importance of clearly defining a product's liabilities and warranties, especially if you deal with third-party vendors. You can be sued by customers for product defects for items that your business doesn't even manufacture, yet you may spend thousands of dollars in legal fees defending your business in the lawsuit. So next is fraud and unsecured transactions. Now, incidences involving payment fraud and other issues related to online security have skyrocketed over the past few years, coinciding with the growth of the e-commerce industry. One report projected that card-not-present fraud will grow by around 14% annually up to 2023, and which is a significant figure for e-commerce platforms that accept on-site payments. Besides protecting customers' information in your site, it is important to delve into inner workings of your e-commerce to prevent fraud. Just because your customers don't walk through a physical store doesn't mean your e-commerce platform is above the law. Take time to ensure your online store meets stipulated regulations across all the jurisdictions that your products or services are sold to potential customers. And sometimes this is the most difficult part, because if you are a transactional lawyer handling cross-border transactions, you don't just rely on the advice of local counsels. At the end of the day, you also have to make comparisons with regulations across all jurisdictions. Next is intellectual property right infringement. Protecting company copyrights and trademarks is another legal concern for today's e-commerce businesses. Some people have likened the internet to the Wild West, where laws and regulatory bodies are largely absent. Although this isn't entirely true, the openness of the web makes protecting your intellectual property in cyberspace a serious challenge. For instance, if a small business owner decides to enter the digital realm of e-commerce, their name, logo, and content can be stolen by other web users if they don't have the appropriate copyrights and trademarks. In reality, losing a logo or a company name can spell disaster for a business, especially a smaller business or a recent startup. Next on is data protection and privacy. Among the top concerns for new e-commerce business is the issue of handling sensitive consumer data. Laws concerning consumer data in the US, for example, are rather rudimentary and can vary state by state. However, data retention and information privacy is consistently among customers' top concerns, especially in recent months. For this reason, it is crucial to have a well-written, comprehensive, and attorney-reviewed privacy policy. Most e-commerce platforms are a reservoir of sensitive customer information, which is often collected via contract forms, customer registration, and during the checkout process. Now, in many countries, e-commerce sites are required to protect customers' data. Next one is political risk and government agenda. An obvious risk for international business is political uncertainty and instability. Countries in emerging markets that may offer considerable opportunities for expanding global businesses may also pose challenges, which more established markets do not. Before considering expansion into a new or unknown market, a risk assessment of the economic and political landscape is critical. Issues such as ill-defined or unstable policies and corrupt practices can be hugely problematic in emerging markets. A growing trend towards economic nationalism also makes the current global political landscape potentially hostile towards international businesses. For instance, companies like Facebook are banned in China, partially in preference for national social networks, and also due to government regulation over internet content. Monitoring political developments and planning accordingly can mitigate political risk of doing business abroad. This is the same in the Philippines, where there are a number of businesses that are subject to the Foreign Investment Act of the country, and it is also subject to the Foreign Investment Negative List, where share ownership of foreigners or investors are subject to certain thresholds depending on the type of industry that the foreigner would want to engage in. The third challenge in cross-border transactions is complexity of transactions and legal risk. Now, cross-border transactions are complex and considered disproportionately challenging and risky by businesses and legal advisors. Lawyers that can advise confidently and demystify these challenges will play a critical leading role in helping their own and their clients' businesses to grow. Along with getting your company structure in place, gaining a comprehensive understanding of the local laws and regulations governing your target markets is key. From tax implications through trading laws, navigating legal requirements is a central function for any successful international businesses. And my last slide would be on...
I'm sorry to interrupt, Dr. Ismail, but you're running out of time.
Okay,
2 minutes.
Can you have 2 minutes? Okay, no worries. So for opportunities, we have sources of information has become easy to find. Now with the proliferation of cloud companies or storage companies that store data, the practice of cross-border transaction has become relatively easy. Of all the challenges going on in the world, the internet is the one development that many people believe makes our world a smaller place, a flat or flattening world, according to Thomas Friedman. Now, there are increasingly widespread and recognized global norms for transaction structuring, drafting language, and governing law, which can be found in the internet. And frequently, these have US and UK origin. And as I said earlier, these drafts can be easily found in the internet. The second opportunity is the impact of technology. So access to the internet has changed the way we do business. Internet is seen as a revolutionary medium for collaboration and interaction between individuals and their computers, regardless of geographic location. In a broad sense, international e-commerce, the most important cost savings aspect of e-commerce is reduction in travel, administration, communication, and market search costs. E-commerce is being promoted in global South economies because it enables their producers and exporters to overcome traditional limitations. And lastly, increasing volume of cross-border work. Now, at a time when the global economic power and growth in the world has been shifting away from the traditional players to emerging markets, it can be no surprise that cross-border transactions have grown. Thank you.
Thank you so much. That was very informative. Теперь мы переходим к последнему спикеру.
And now we are transitioning to the next speaker, Ali Mahmudov, who is the managing partner of a legal marks solution, bringing Kazakhstan brands to international market.
We can see you all as well, okay? Very interesting format. I don't see myself at all, but I think it's going to be interesting. I'll ask organizers to start my presentation. Can you see my presentation?
Вы можете попробовать экран.
The demonstration of screen is starting now. You can move the screen to the right and to the left. Maybe your screen is in a different tab. Anyways, I can continue like that. Most importantly, you can see me. It's a very interesting conversation from other colleagues. And if we go back to my topic, I would like to again state some interesting cases, because as was stated before, as of now, all of the producers, they try to find a new market or try to scale up abroad and try to protect their interest in the markets, and then again receive certain priorities in that and different issues. So especially when we talk about development of a marketplace, about development of various international players, this issue becomes relevant. Another thing why this is important is when in our company we had an organization who asked the consultation, and then they explained that a few years ago when they did the European Championship on soccer in Ukraine, the national manufacturer decided to earn some money on that, and then they some wagons of shipments of socks of UEFA symbols and sent it to the
чемпионата. И, соответственно, огромная
part of this championship. So huge part of shipments was stopped at the custom clearance, and during the customs, it was found out that the marking of this textile products violates certain intellectual properties, and that the trademarks are being violated, and the trademarks of UEFA are being protected by certain international treaties and contracts, and the importer had carried out many losses because they would not be able to get it through the customs. So then they had to cancel it. Now I see the presentation. Thank you. Another very similar situation is one of the regional producers of the food manufacturers, while has one of the main market is Afghanistan, it was found out that there was a certain supply which was stopped by Afghanistan customs, and in that case, the shipment was stopped, which, as per the opinion of the Afghan bodies, violates the rights, intellectual property rights of the certain Afghan company, which was registered themselves as a foreign brand and would not allow to foreign manufacturers to reach the Afghan market. The reason why I give this example is because you take certain markets, certain products to the market, it's very important to remember about two items. First of all, that your product or service does not violate the rights of the intellectual property or some other rights of the existing players in the market. And second, to take measures in case if everything will be successful and there will be some malicious companies or malicious players that they could not impact your business, or again to stop your business from functioning. So this can be done by several procedures. First of all, before the market has been reached, first you check the base of the trademarks, and it's better to do in advance. Why? Because if we talk, for example, the nearest countries, then the trademarks which are registered in these countries, which look similar, they could be, you might not even know about that. And the list of such trademarks, it's on 1 or 2 pages. And if you make such list as if it's in Russia, there may be like 45 trademarks. If you do it in UAE or China, there may be like 125, maybe even more. So it's important to have a consultant or for other partners that do this type of activity to analyze the data, analyze information, and then make a certain report on risks. It's also important if we will be talking about the certain goods.
На экспорт или импорт товаров отсутствует, очень важно зарегистрировать данные бренды в соответствующих странах. И тут вот очень часто возникает вопрос у наших клиентов, ну и вообще этот вопрос очевиден, то есть существует ли некий такой единый... Здесь, к сожалению, ответом будет нет, такого единого товарного знака нет. И, как правило,
no, because oftentimes each country has its own registration. So in each country, you have to separate the register, and then there are certain exceptions, and you need to remember about those because it significantly impacts the strategies. Like certain jurisdictions, certain organizations, they have the unified trademark, which is valid for several countries as part of a certain treaty. For example, if you're talking about export to Africa, then there are certain procedures where you can register one trademark and it will cover 16 French-speaking countries or certain countries which do not speak French. And again, there is a unified trademark for European Union, and then you can fill out the unified application and then protect your trademark in 28 countries by default. So Each case should be reviewed individually, and it's important that your clients, our clients, and the producers would not make a mistake. And why? Because via just regular open sources, via internet, it's very difficult to do the check because majority of information is in the closed database or in some national database, which do not also, being refreshed all the time, so have limited information, and which also has certain costs. So if those recommendations will be implemented, it's important to see that and to realize, implement the tools of the custom protection by actually introducing the trademarks in the custom registry. For some, it's a problem. For some, it's not. But it's negative effect. It's a parallel import, the so-called gray import. And in case if you do certain supply to certain countries, the similar countries, similar goods from the similar countries will be provided and will affect the distribution. So the custom register is a tool which allow you to coordinate and control the parallel import. And if you're not interested in parallel import, you can give instructions to the customer.
Оформление. Это достаточно большая тема, и если она интересна, и мы можем о ней отдельно.
If you're interested, we can talk about it separately. So one more example why it's important to follow the custom register. One of the clients, which is a large producer of the juices, and they provide the juices to China, and then one of the supply was stopped on Xinjiang autonomous district. It's known because in the trademark, oftentimes they track the goods which are entering the market. They are registered for themselves, and then they basically do some form of a pressure on export. And in that case, our client had faced that because there's a certain legal entity being registered in Xinjiang, and it was very difficult to have a dispute about this trademark. It was very complicated because Uyghur Autonomous District is a very specific region. It's a huge political issue. Not all of our colleagues which are located in Shanghai or Beijing, they can do some form of activity on that district, on that company. The companies could provide the quality services for this autonomy district. So all of it caused certain difficulties and time difficulties and I have a small question. Could you tell more about practice on disputing such improper registration when the international trademark, or for example, some international trademarks were registered on an entity which does not have a right to do such registrations? I know there is a procedure for dispute and how it's done. Well, actually, we face this quite often because, as I said, many companies, they made this their business, and we can see that in different countries, there are various schemes on how you can contradict this these contestations, this litigation, and all of it is usually has something related to do with the custom registry. So in case of our Chinese experience, then to count on Chinese courts, it's almost, in our case, almost impossible. Why? Because they oftentimes, support their own national Chinese companies. Not every lawyer can, provide.
Для того, самое главное, даже если есть решение суда, его исполнить в Китае очень тяжело. Почему? Потому что
real game executed because about arbitrage, it's one thing, and it's.
Они, конечно, как правило, подаются в государственные суды, так как там нет соответствующих оговорок и так далее, и все это накладывает свой отпечаток. И в случае с Китаем наиболее эффективный метод.
Talking about China, the most effective method is to work through police, through organizations which have something to do with the trade chamber. Why? Because they don't like too much noise of international companies, and the police works more or less effective, especially in the cases of certain political aspects. So in this specific case, it's more effective. However, if you talk about like Arab countries, and in that the prosecutor works quite well. So in Emirates, for example, in one prosecution office in Kuwait, it's another. Why there are too many disputes in those countries? Because these countries oftentimes are the trade ports for further export to Africa, and they signed majority of international treaties on protection of international rights. And if you're talking about UAE, it's also part of the treaty. So of course, which also has something to do with the registration of the trademark with more than 5,000 USD. If it's more than 5,000 USD, you can register in 5 or 6 countries. Therefore, in those countries, of course, it's better to go through police. But if you talk about countries like Ukraine, then in those cases, it's again a big country where there's certain demand for regional products. Then, of course, we have a combined approach, but oftentimes the negotiation process works quite well. So for a small amount, you can either buy a brand or you can find certain leverages to punish the person that is doing some illegal activity. So each case is individual. There is no unified approach which would resolve all of the problems, but there are many approaches which could give a result similar about protection of those brands, because some will try to protect it, some will try to protect by registration of trademark, author rights, or industrial samples, but most effective is a combination of various approaches. In this case, as I said, should be reviewed individually. Another question to clarify, what about copying the external view of the product? If we copy, for example, only external view, is there certain specificities on that? It's a huge problem, especially if we talk about international big companies which have 200, 300 trademarks in their portfolio. Of course, depending on the priority of a certain country, a certain market, they register certain key brands, 10, 15, 20, not, of course, not all 500. And sometimes there are cases when there's a lookalike limited products when they copy the trackers, and it's very apparent in pharmaceutical business when the color panel, the packages are being done. It's the same in consumer goods. We even electronics. We had cases with when we identified counterfeit escalators, where in certain countries there were dozens of Volvo escalators. They look alike like Volvo, but they're not Volvo. They were Chinese product with the different characteristics and were marked as a Volvo. And it's a big mistake on identifying. There's a technical surveillance and where they regulated, on whom regulated, and how they bought it, and it's a huge work. If you talk about lookalike, since in this case go by the way of stoppage of this trademark, it's very difficult since there is no trademark registration. One of the recommendation again is approximately, it goes on, it depends on the specific cases, is to have anti-monopoly bodies which reviews the cases which has to do with the violation of some external view or some of the key moments that that are being used by the original producer. So again, it's more the help of the anti-monopoly body, but again, it needs to look separately. Thank you. It was the last presentation for today. Do you have some comments, questions? Because so far we did not have any One thing which I want to say is that I would like to finish while we talk about goods. I also want to mention about services, because oftentimes there's a situation when original, let's say, specialists, especially in IT, they develop certain products, they took it to international market, they monetize it in different countries, of course, more developing countries. And then it's important about protection of author rights, because author rights, they are raised when it's about created. You don't need to register them because the authors created them. However, there should be the deponent process or registration in certain organizations. Why? For the developer to be able to prove their authorship. When the third parties will buy this product, they need to have the presumption that they're buying the someone who is the author, who this product was not stolen and is not under other parties. So the protections of the author rights is very important to remember about that. And here, why I recommend, because we can, for example, register that right in any country, and any document in Russia or in Kazakhstan or elsewhere in other countries of the Union, but it would require certain apostille legalization, bureaucracy. And Roman had comment. First, you said about the example about SOX, about unified so-called partisan marketing. We had faced it many times. So when we talk about Olympiad Games, because when Olympiad Games starts, everyone starts to produce T-shirts and socks. And International Olympic Committee is very rigid on that. If it's a hosting country, should host a lot of obligations, especially to track it all on customs. So what I faced in two Olympiad and various approaches, Olympiad in Sochi and Olympiad in London in 2012. In London, the law on the partisan marketing, it was much more weighted because in the parliament, there are two lobbies were faced. On one side, it was a lobby of Olympic Committee. On another side, all the marketing industry united, and they said, listen, it's all good, but we want to have some profits from Olympic Games as well. So this is the strict regulations. In that case, we don't need the Olympic. We also need to make money on that and pay you taxes. And in Russia, it was a different approach. When Vladimir Putin took role to Duma, everyone just accepted it in the first production, and the regulation was much more strict on this partisan marketing. But in general, it was MOC required to rename.
Вот они требовали его переименовать. Все, что там со словом «олимпийский» связано, в принципе, я тогда смеялся и говорил, что по закону там...
The speaker is not heard. Everything that was connected with the word Olimpийский, for example, probably we need to rename the books on Olympics. And another interesting moment, the first agreement that was signed by the Soviet Union, and it was lobbying in France. And it turns out that Charles de Gaulle book was translated into Russian, and they made some notes. And when he saw it, he asked to translate it again, and he was shocked with these comments. And his lawyers said actually the Soviet Union didn't have any agreements on the copyright, and he was the ambassador that was responsible about the copyright in the Soviet Union. Thank you very much. Very interesting addition. It would be great if he, for example, promoted the execution. Probably it would be priceless. And the biggest problem here, for example, let's take the championship, the football championship in Russia. They took the team, and when Russian fans just went to all the shops and they decided to take and the booths with the signs of the championship. They didn't take other brands, but as for the symbols of championship, it was under the special control. Thank you very much, because we do not have enough time. I would like to thank all the participants. And now we do not have any comments or questions, and thus we can complete the work of our session. Thank you very much. Thank you. Thank you for very interesting presentations. I would like to thank all the speakers, all the participants who were very active and asked different questions. Thank you very much. And the record will be available. All the materials of our presentations will be available from our speakers. Thank you very much. Goodbye. Thank you. Goodbye.
Друзья, мы скоро начнем. Можете не отключаться на перерыв, потому что немного выбились из графика, поэтому можете не отключаться. Мы буквально через минуту.
Dear friends, we are starting our next session in 1 minute. Please be online.